In 1911, on a Saturday afternoon in March, a fire broke out on the 8th floor of a 10-story building in Lower Manhattan. The building housed the Triangle Shirtwaist factory. Inside were nearly 500 workers, mostly young immigrant women, many of them teenagers, sitting at sewing machines in a room packed so tightly with fabric and machinery that there was barely space to walk between the rows. The doors to the stairwells were locked. The factory managers locked them during working hours to prevent workers from taking unauthorized breaks and to stop them from stealing fabric. The fire spread through the piles of cotton scraps on the floor in minutes. Workers who reached the doors found them locked. Workers who reached the windows found the fire escape had collapsed under the weight of the people trying to use it. Workers who could not find another way out jumped. Witnesses on the street below watched bodies fall for almost 15 minutes. 146 people died. The youngest was 14 years old. The owners of the Triangle Shirtwaist factory, Isaac Harris and Max Blank, were tried for manslaughter. They were acquitted. A subsequent civil lawsuit produced a settlement of $75 per deceased worker. And here is the fact that makes the Triangle fire not just a tragedy, but a window into the entire system that produced it. The locked doors were not illegal. There was no law that said factory doors had to remain unlocked during working hours. There was no law that required fire escapes capable of supporting the weight of the people who might need to use them. There was no federal agency with the authority to inspect the Triangle factory, identify the hazards, and require the owners to fix them before 146 people died. The Occupational Safety and Health Act, which created the federal agency with exactly that authority, was not signed into law until December 29, 1970, 59 years after the Triangle fire, 181 years after the Constitution was ratified. For 181 years, the federal government of the United States had no general authority to regulate workplace safety. Workers who were injured or killed on the job had essentially no federal legal protection. The conditions in which they worked, the hazards they were exposed to, the machinery they operated, the chemicals they breathed were determined almost entirely by their employers, constrained only by whatever state laws existed and by the pressure of the market. The market, it turned out, was not particularly good at keeping workers alive. This is the story of what American workplaces actually looked like before anyone was required to make them safe. It is the story of the industries that killed workers at rates that are almost impossible to comprehend today, of the companies that calculated the cost of worker deaths against the cost of safety improvements and chose the deaths, of the reformers and labor organizers who spent decades trying to change a system that was legally entitled to kill the people who worked in it, and of the political battles that finally produced a law after more than a century of workers dying in conditions that everyone knew were preventable. To understand the scale of what existed before 1970, you need numbers. Not abstractions, but actual numbers, because the magnitude of industrial death in pre-OSHA America is genuinely difficult to comprehend without them. In 1913, the Bureau of Labor Statistics estimated that approximately 23,000 workers were killed in industrial accidents in the United States. That is a single year, 23,000 people who went to work and did not come home. To put that in context, the United States lost approximately 53,000 soldiers in combat during the entire Vietnam War. American industry was killing workers at nearly half the rate of active combat every year in peacetime. Coal mining alone killed an average of more than 2,000 workers per year in the early 20th century. The Monongah mining disaster in West Virginia in December 1907 killed 362 miners in a single explosion, the worst mining disaster in American history. The Cherry Mine disaster in Illinois in 1909 killed 259. The Eccles Mine disaster in West Virginia in 1914 killed 181. These were not freak accidents. They were the predictable consequence of operating mines with inadequate ventilation, inadequate shoring, inadequate gas detection, and no meaningful external oversight of any of these conditions. The steel industry was killing workers at comparable rates. The blast furnaces, the molten metal, the overhead cranes, the hot metal rail cars, the inadequate safety equipment, and the punishing pace of work in American steel mills in the early 20th century produced an injury and death toll that companies tracked as a routine operating cost. U.S. Steel, in a 1906 internal study, calculated that it was spending approximately $500 per worker killed and $50 per worker seriously injured. The study was not produced to reduce deaths. It was produced to determine whether the cost of safety improvements was justified by the reduction in injury costs. In many cases, the calculation came out against safety. The railroads were equally deadly. Railroad workers in the late 19th and early 20th centuries were killed and maimed at rates that would today constitute a national emergency. Brakemen, who had to ride on top of moving cars and operate brakes manually, fell to their deaths regularly. Coupling workers, who had to stand between cars to connect them with link and pin couplers, lost hands and arms at a rate so consistent that the missing hand became an occupational marker. The automatic coupler, which eliminated the need to stand between cars, was available for decades before it became legally required. Companies resisted mandating it because of the cost of retrofitting existing cars. The Locomotive Boiler Inspection Act of 1911 and the Federal Employers' Liability Act of 1908 provided some protection for railroad workers, making it easier to sue railroads for injuries and requiring inspection of locomotive boilers. These were meaningful reforms in specific industries. They were not general workplace safety standards. They left untouched the vast majority of American workplaces. The chemical and industrial disease problem was in some ways even more severe than the acute injury problem because it was less visible. A worker who fell into a blast furnace died immediately and dramatically. A worker who spent 20 years breathing coal dust developed black lung disease and died slowly, over years, in a process that was difficult to attribute conclusively to the workplace and therefore difficult to compensate or regulate. Alice Hamilton was the first physician to systematically document industrial disease in the United States. Beginning in 1910, Hamilton traveled through American industrial facilities documenting the health effects of specific exposures: lead in paint factories, phosphorus in match factories, mercury in hat making, carbon monoxide in steel mills. Her work was meticulous, scientifically rigorous, and largely ignored by industry and government alike for decades. The phosphorus necrosis problem in match factories illustrates how these situations worked. White phosphorus, used in the manufacture of matches, caused a condition called phossy jaw in workers exposed to it. The phosphorus vapor would enter through a cavity or any small wound in the mouth, infect the jawbone, cause it to rot and glow green in the dark, and ultimately kill the worker, usually after years of agonizing deterioration. The condition was entirely preventable. A safe alternative phosphorus compound existed and was being used in European match factories. American match companies refused to switch because the safe compound was more expensive and required retooling of machinery. The match companies could do this because there was no law requiring them to do otherwise. Phossy jaw was not illegal to cause. It was a cost of working in a match factory, borne by the worker rather than by the company, because the legal system assigned the cost to whoever happened to be present when the harm occurred, which was always the worker. The legal framework governing workplace injury in this era was built around three doctrines that made it essentially impossible for injured workers to recover damages from their employers, regardless of how negligently the employer had behaved. The first was the assumption of risk doctrine. Under this doctrine, a worker who took a job was assumed to have accepted the known risks of that job. If a coal miner took a job in a mine and was then killed by a methane explosion, the company could argue that methane explosions were a known risk of coal mining, that the miner had accepted that risk when he took the job, and that the company therefore owed him nothing. The doctrine was applied with a breadth that bordered on absurd. Workers were found to have assumed risks they had no knowledge of, that they had no practical ability to avoid, and that resulted from specific negligent acts by their employers rather than from the inherent nature of the work. The second doctrine was contributory negligence. Under this doctrine, if an injured worker had contributed in any way to their own injury, they could not recover damages from their employer at all, not partial damages, nothing. A worker who was injured because a machine lacked a required safety guard, but who had been momentarily inattentive when the injury occurred, was barred from any recovery because their inattention contributed to the accident, even if the primary cause was the absent safety guard. The third doctrine was the fellow servant rule. Under this doctrine, an employer was not liable for injuries caused by the negligence of a fellow employee. If a worker was killed because a coworker made an error, the employer owed nothing. The worker had to sue the coworker instead, who typically had nothing worth suing for. These three doctrines, taken together, created a legal system in which workplace injury was almost entirely the economic problem of the worker. Companies could maintain dangerous conditions with essentially no legal liability for the consequences. Workers who were injured had no meaningful legal recourse, and workers who needed the income from dangerous jobs had essentially no power to refuse the dangerous conditions, because refusing meant unemployment. This was not an accident. These doctrines were applied and maintained by courts that were, in the early industrial era, deeply sympathetic to property rights and deeply skeptical of claims that would impose costs on industrial development. The application of assumption of risk to the coal miner killed by a methane explosion was a legal choice made by judges who believed that protecting industry from liability was more important than compensating workers for their deaths. The workers' compensation movement, which began in the early 20th century, represented the first significant breach in this system. Workers' compensation laws, passed by most states between 1910 and 1920, established a system in which workers injured on the job received a fixed schedule of benefits without having to prove employer negligence in court. In exchange, workers gave up the right to sue their employers for negligence. The trade-off was explicit. Employers got immunity from tort liability, workers got predictable if modest compensation for their injuries. Workers' compensation addressed the compensation problem without addressing the prevention problem. It made it easier for injured workers to receive something when they were hurt, but it did not require employers to prevent injuries in the first place. In fact, by capping employer liability at the workers' compensation schedule rather than exposing them to unlimited tort damages, it arguably reduced the financial incentive for employers to invest in safety. The compensation was an operating cost. Preventing the injury was an investment. The calculation frequently favored the compensation. State safety laws existed in this period, but they were inconsistent in coverage, inadequate in standards, and poorly enforced. The states that had the most dangerous industries, the coal states of West Virginia and Kentucky, the steel states of Pennsylvania and Ohio, tended to have the weakest safety regulation, because the industries with the most to gain from weak regulation were the most politically powerful in those states. A West Virginia state legislature dependent on coal company financing was not going to impose meaningful safety costs on coal companies. The federal government's role in workplace safety before 1970 was almost non-existent in most industries. The Bureau of Mines, established in 1910 after the Monongah disaster, had the authority to inspect mines and make recommendations, but no authority to require mine operators to implement those recommendations. The Walsh-Healy Public Contracts Act of 1936 required companies with federal government contracts to meet certain safety standards. The Longshore and Harbor Workers' Compensation Act covered maritime workers. These were islands of regulation in an unregulated sea. The political barriers to federal workplace safety legislation were substantial and persistent. Industry lobbied aggressively against any federal safety standards, arguing that workplace safety was a matter for employers and states, that federal standards would be inflexible and costly, and that the market would punish employers who maintained unsafe workplaces. The market argument was transparently false in industries where workers had no alternative employment, where the costs of moving were prohibitive, and where the health effects of workplace exposures took years or decades to manifest, but it was repeated with conviction by industry representatives for decades. The labor movement supported federal safety legislation, but the labor movement's political power was limited, particularly after the legislative defeats of the late 1940s, including the Taft-Hartley Act, which restricted union organizing and reduced labor's political leverage. The unions that represented workers in the most dangerous industries were often more focused on wages and job security than on safety, both because safety was harder to bargain over and because in many cases the workers themselves prioritized income over safety in conditions where the alternative to a dangerous job was no job. What finally broke the political logjam was a combination of factors that came together in the late 1960s in ways that made federal workplace safety legislation politically possible for the first time. The first factor was the publication of reliable data on workplace injury and death that made the scale of the problem impossible to ignore. By 1968, the Bureau of Labor Statistics was reporting approximately 14,000 worker deaths per year from workplace accidents, with an estimated 2.2 million workers suffering disabling injuries. These numbers were almost certainly undercounts because reporting was voluntary and employers had strong incentives to underreport. But even the official numbers were staggering. The second factor was the Farmington mine disaster of November 1968, which killed 78 miners in West Virginia in a methane explosion. The disaster was extensively televised, bringing the reality of mine deaths into American living rooms in a way that the statistics had not. Secretary of the Interior Stuart Udall visited the mine and publicly acknowledged that the federal government's approach to mine safety had been inadequate. The disaster galvanized support for what became the Federal Coal Mine Health and Safety Act of 1969, the first law to give the federal government real enforcement authority in a specific industry. The third factor was the broader political moment of the late 1960s, characterized by consumer protection advocacy, environmental awareness, and a general skepticism of corporate power that made regulatory legislation politically viable in ways it had not been for decades. Ralph Nader's campaign against automobile safety in the mid-1960s, which produced the National Traffic and Motor Vehicle Safety Act of 1966, demonstrated that consumer and worker protection legislation could pass Congress and that it had significant public support. President Nixon, who signed the Occupational Safety and Health Act in December 1970, was not particularly enthusiastic about it. He was responding to political pressure from organized labor, which had made workplace safety a priority, and to the broader political reality that doing nothing on the issue was more costly than passing the law. Nixon's signing statement acknowledged the human costs of workplace injury while emphasizing the importance of not imposing unnecessary burdens on business. The law itself was a compromise. It created the Occupational Safety and Health Administration within the Department of Labor, with the authority to set and enforce mandatory safety standards in workplaces across the country. It created the National Institute for Occupational Safety and Health to conduct research on workplace hazards. It gave workers the right to request inspections, to receive information about workplace hazards, and to refuse work they reasonably believed presented imminent danger. But the law also contained significant limitations. Enforcement depended on OSHA's capacity to conduct inspections, which was always insufficient relative to the number of workplaces covered. Penalties for violations were modest and have remained modest relative to the financial resources of large employers. The standard-setting process was slow and cumbersome, requiring extensive scientific documentation and surviving legal challenge from industries that routinely sued to block new standards. Agriculture, the most dangerous industry in America by injury rate and the one employing the largest number of workers in poverty, received limited coverage under the original law. The results since 1970 are nonetheless significant. Workplace fatality rates have fallen by approximately 65% since OSHA was established. The raw number of worker deaths has fallen from approximately 14,000 per year in 1970 to approximately 5,000 today, in a workforce that is roughly twice as large. The decline in specific hazards where OSHA has set and enforced standards has been even more dramatic in some cases. Brown lung disease from cotton dust has been largely eliminated. Silicosis from silica dust has been significantly reduced. Acute lead poisoning in industrial workplaces has fallen dramatically. These are real achievements. They represent tens of thousands of workers alive today who would have been killed or permanently disabled without the law. They represent families that remained intact, communities that retained members, economic productivity that was not lost to preventable injury and death. But the story of what OSHA has achieved is also the story of what it has not achieved, and the gap between the two is significant. The penalty structure of the law has not kept pace with inflation or with the scale of corporate resources. A serious violation of OSHA standards carries a maximum penalty of $15,225 per violation. A willful violation, one where the employer knew about the hazard and chose not to fix it, carries a maximum of $156,259. For a company with billions in annual revenue, these penalties are not deterrents. They are operating costs to be weighed against the cost of compliance and frequently found cheaper than compliance. The BP Texas City refinery explosion in 2005, which killed 15 workers and injured 180, resulted in OSHA fines totaling $21 million, the largest in OSHA's history at the time. BP's revenue in 2005 was approximately $250 billion. The fine was roughly 0.008% of annual revenue. BP paid it and continued operating. The Upper Big Branch mine disaster in West Virginia in 2010 killed 29 miners. The mine, operated by Massey Energy, had been cited for safety violations more than 500 times in the preceding years. The violations were cited, fines were assessed, and the mine continued to operate with the same hazardous conditions because the fines were cheaper than fixing the problems. 29 people died who would not have died if the fine structure had been sufficient to change the cost-benefit calculation. The agricultural exemption in OSHA's original coverage has never been fully corrected. Farm workers, who are disproportionately Latino and immigrant, work in conditions that would be illegal in any other industry. Exposure to pesticides without adequate protective equipment, heat illness from working in fields without water or shade breaks, sanitation conditions that are non-existent in many cases, all of these hazards are inadequately regulated for agricultural workers in ways that would be inconceivable for workers in other sectors. The pattern is consistent with the history that preceded OSHA's creation. The workers with the least political power, the least access to legal resources, and the fewest economic alternatives bear the most risk. The workers who most need the protection of safety law are the workers who are least likely to receive it, because the industries that employ them are the most resistant to regulation and the most successful at avoiding its application. The gig economy has created a new category of workers who fall outside OSHA's coverage in meaningful ways. Workers classified as independent contractors rather than employees are not covered by OSHA standards. The classification of workers as independent contractors, which saves employers the costs of employment taxes, benefits, and legal compliance, is widespread in industries like construction, delivery, and transportation that have significant injury rates. The workers doing the most dangerous jobs are in many cases classified in ways that strip them of the legal protections that were designed for exactly their situations. The ergonomic standard is perhaps the clearest example of the political limits on OSHA's authority. Ergonomic injuries caused by repetitive motion, awkward postures, and forceful exertions, account for roughly one-third of all workplace injuries in the United States. OSHA developed a comprehensive ergonomic standard over more than a decade of scientific research and stakeholder consultation, finalizing it in November 2000 under the Clinton administration. In March 2001, the newly inaugurated Bush administration and a Republican Congress repealed the standard under the Congressional Review Act, the only time in OSHA's history that a completed standard has been legislatively repealed. No comprehensive ergonomic standard has been issued since. The chemical regulation problem is equally significant. OSHA's authority to set permissible exposure limits for workplace chemicals is constrained by the same cumbersome standard-setting process that limits all OSHA regulation, and the agency has been unable to keep pace with the proliferation of new chemicals in the workplace. Most of OSHA's permissible exposure limits were set in 1971, based on the scientific knowledge of that era, and have not been updated to reflect subsequent research showing that many of the original limits were set too high. Workers are legally exposed to levels of certain chemicals that current science indicates are harmful, because updating the standards requires a regulatory process that takes years and survives industry legal challenge. The asbestos story illustrates how slowly this process can work even in the clearest cases. The link between asbestos exposure and mesothelioma, a fatal cancer, was established in the scientific literature in the 1950s and 1960s. OSHA issued its first asbestos standard in 1971, one of its earliest regulatory actions. The standard was progressively tightened over the following decades as the evidence of harm at lower exposure levels accumulated. But asbestos was never banned in the United States, as it was in most other developed countries. It remains legal to use in certain applications. Workers in industries that involve contact with legacy asbestos, including construction, renovation, and demolition, continue to be diagnosed with mesothelioma decades after the hazard was definitively established. The international comparison is instructive here. Most Western European countries have significantly stronger occupational safety regulatory frameworks than the United States. Norway, Finland, Sweden, and Denmark have workplace fatality rates roughly half those of the United States, in economies with comparable levels of industrial development. The difference is not a product of the inherent dangerousness of work in those countries. It is a product of regulatory standards, enforcement capacity, and the political power of workers relative to employers in those societies. Germany's system of joint employer-employee safety committees, in which workers have formal authority to participate in workplace safety decisions, produces safety outcomes that are significantly better than the U.S. employer-dominated model. The British Health and Safety Executive has enforcement tools and penalty structures that are more effective deterrents than OSHA's. These are not coincidences. They are the products of different political settlements about who bears the cost of workplace risk. The American settlement, established in the legal doctrines of the 19th century and modified but not fundamentally changed by OSHA in 1970, continues to place a significant portion of workplace risk on workers rather than employers. Workers accept jobs knowing that injury is possible. Workers' compensation provides fixed benefits for injuries that occur. OSHA provides a floor of safety requirements that employers must meet, but the floor has significant gaps, the enforcement is underfunded, the penalties are insufficient, and the workers with the least power continue to bear the most risk. The 14-year-old who died in the Triangle Fire in 1911 could not have imagined a world in which the federal government had 2,100 inspectors responsible for enforcing safety standards in 8 million workplaces. She also could not have imagined that 113 years after her death, 5,000 workers per year would still be dying in American workplaces, that construction workers would still be falling from scaffolding, that farm workers would still be dying of heat illness in fields, that warehouse workers would still be suffering crush injuries from inadequately guarded machinery. The progress is real. The work is not finished. The story of workplace safety in America is the story of a society slowly, incompletely, and with constant resistance from those with the most to gain from inaction, coming to terms with the fact that workers are not simply factors of production, whose injuries and deaths are acceptable costs of industrial output. It is the story of the distance between that proposition, which seems obvious when stated plainly, and the legal and political systems that have taken 200 years to partially implement it. That distance, still measurable in the 5,000 deaths per year that occur in American workplaces today, is the distance between the world the Triangle workers lived in and the world their descendants still inhabit. The law changed in 1970. The underlying problem is still being solved. Subscribe if this kind of history is what you are here for. There is a great deal more of it ahead. To fully understand the world that existed before OSHA, You need to spend more time in the specific industries that were killing workers at the highest rates, because the aggregate statistics obscure the particular horror of what daily working life actually looked like in these places. Coal mining in the early 20th century was perhaps the most lethal peacetime occupation in human history. The physics of the work made it inherently dangerous in ways that safety investment could reduce but not eliminate. Underground spaces could collapse, methane could accumulate and explode, coal dust could ignite. But the gap between the inherent hazards of mining and the actual death toll was largely a product of choices that mine operators made about ventilation, about timbering, about gas detection, about how fast to push production relative to the safety margins that slower work would have provided. The Monongah disaster of 1907 happened in a mine owned by the Fairmont Coal Company, a subsidiary of Consolidated Coal. The explosion that killed 362 men and boys was caused by a combination of inadequate ventilation that allowed methane to accumulate and coal dust that amplified the initial explosion beyond what it would otherwise have been. Both of these conditions were known hazards. Both were addressable through investment in ventilation and dust suppression. Neither had been adequately addressed because the investment was costly and the Bureau of Mines had no authority to require it. The mine employed boys as young as 12 as trappers, whose job was to open and close ventilation doors to allow the coal cars to pass. Some of the bodies recovered from Monongah were those of boys who had been legally employed underground in the most dangerous workplace in America before they were old enough to vote, drink, or enlist in the military. After Monongah, Congress held hearings. The Bureau of Mines was created in 1910. Investigations were conducted, reports were written, and mines continued to kill workers at rates that would not meaningfully decline until the Federal Coal Mine Health and Safety Act of 1969, 62 years after Monongah, gave the federal government real enforcement authority for the first time. The steelmaking industry presented a different set of hazards. The blast furnace process involved temperatures high enough to instantly kill anyone who came into contact with the molten metal, and the facilities were organized around the need to move that metal through a series of processes that brought workers into close proximity with it constantly. Overhead cranes carrying ladles of molten steel, hot metal rail cars, transfer pits filled with slag, tapping operations that released streams of liquid metal at temperatures above 2,500 degrees Fahrenheit. The potential for catastrophic injury was present at every stage of the process. The management of these hazards was largely left to individual employers, and individual employers varied enormously in how seriously they took it. Some steel companies invested in safety equipment, trained workers, and maintained procedures designed to reduce the likelihood of contact with molten metal. Others operated on the principle that the men knew the risks when they took the job, and that additional safety investment was money that could be spent on production instead. The 12-hour shift that was standard in steel mills through the 1920s compounded the hazard. A worker who had been standing on his feet for 11 hours in temperatures that regularly exceeded 100 degrees near the furnaces, handling equipment that required constant attention and physical precision, was a worker whose capacity to avoid accidents was significantly diminished. The pace and duration of work was itself a safety issue that was never formally regulated until the Fair Labor Standards Act of 1938 established the 40-hour week, and even then, the steel industry operated for years with extensive overtime that pushed workers well beyond it. The Bethlehem Steel study of the 1910s, conducted by safety pioneer Frederick Hoffman, found that Bethlehem's mills were producing roughly one serious injury per worker per year. That is not an annual injury rate. That is one serious injury per worker per year, meaning that a steel worker who spent 10 years at Bethlehem could statistically expect to be seriously injured 10 times. The injuries ranged from burns and lacerations, which were common and often disfiguring, to crushing injuries from falling materials, to deaths from contact with molten metal. The rate was considered, by the standards of the time, acceptable. The textile industry, which employed hundreds of thousands of workers in the Northeast and increasingly in the South in the early 20th century, presented yet another set of hazards. Cotton dust was the most significant. Workers in cotton mills inhaled cotton dust continuously throughout their shifts, and the progressive lung disease it caused, byssinosis, known as brown lung disease, disabled and killed textile workers at rates that were not systematically documented until the 1960s. The disease was entirely preventable through ventilation and dust suppression. It was not prevented because there was no law requiring prevention, and because the symptoms developed slowly enough that the connection between the workplace exposure and the eventual disability was deniable for years. The cotton mill owners of the South, who had built an industry on cheap labor in the decades after Reconstruction, were among the most aggressive opponents of any federal regulation of working conditions. They argued that their workers were better off in the mills than they would have been in the agricultural poverty from which they had come, which was sometimes true in the narrow sense that mill wages exceeded farm wages, and they argued that federal regulation would destroy the competitive advantage that low-cost production provided, which was always true. What they did not argue, because they could not plausibly do so, was that the conditions in their mills were safe. They were not. The noise levels in a cotton mill operating full machinery were high enough to cause permanent hearing loss after years of exposure. The dust levels were high enough to cause progressive lung disease. The pace of work was high enough to produce repetitive motion injuries at significant rates. The company housing, company stores, and company-controlled social infrastructure of many mill towns meant that workers who sought to leave faced not just unemployment, but the loss of their homes and access to basic services. The occupational disease problem was, in some ways, more difficult to address than the acute injury problem because it was less visible and more deniable. A worker killed by a falling steel beam died in a way that was immediately and obviously connected to the workplace. A worker who developed cancer after 20 years of exposure to benzene in a chemical plant died in a way that was medically attributable to the exposure, but that the company could contest, delay, and deny through the legal process for years, often until after the worker had died. The legal doctrine of latency, the gap between exposure and disease onset, was exploited by industries whose products caused occupational disease to avoid liability for decades. The asbestos industry knew by the 1930s that asbestos exposure caused fatal lung disease. Internal documents subsequently obtained in litigation showed that the industry's medical consultants had documented the connection and recommended against disclosing it to workers or the public. The industry suppressed this information for decades, continuing to expose workers to levels of asbestos that they knew were lethal, and fighting every regulatory effort to control the exposure. The asbestos litigation that began in earnest in the 1970s and 1980s, after OSHA's creation had begun to put official pressure on asbestos exposure levels, produced the largest mass tort litigation in American legal history. Hundreds of thousands of asbestos-related lawsuits were filed, dozens of companies were bankrupted by the liability, and tens of thousands of workers received some compensation for injuries that had been knowingly inflicted on them over decades. The compensation, when it came, was inadequate in most cases relative to the harm. Mesothelioma, the cancer caused by asbestos exposure, is uniformly fatal, usually within a year of diagnosis. No amount of money compensates for that outcome, and the workers who received no compensation at all, those who died before the litigation reached them, or whose exposure was too diffuse to connect to a specific company, received nothing for injuries that were just as real. The pattern of the asbestos litigation, industry knowledge of harm, suppression of that knowledge, decades of continued exposure, eventual litigation producing inadequate compensation, has been repeated in subsequent decades with other substances. The coal dust litigation that established black lung benefits for miners followed a similar pattern. The silica dust litigation in the 2000s followed the same pattern. In each case, the harm was known, the knowledge was suppressed or ignored, the exposure continued, and workers died. OSHA's creation was supposed to break this pattern by requiring proactive prevention rather than reactive compensation. In some respects, it has. The Process Safety Management Standard, which OSHA issued in 1992 following the Bhopal disaster in India, requires chemical plants to systematically analyze their processes for potential catastrophic failures and implement safeguards before a disaster occurs, rather than after. The standard has prevented a number of catastrophic industrial accidents that would otherwise have occurred. But the standard-setting process that produces standards like the Process Safety Management Rule is slow, resource-intensive, and legally vulnerable. Industry groups routinely challenge new OSHA standards in court, arguing that the agency has not met its statutory burden of demonstrating that the standard is technologically and economically feasible and that it addresses a significant risk. These legal challenges are frequently successful in delaying implementation and sometimes in overturning standards entirely. The result is that OSHA's regulatory output is far smaller than the pace of new workplace hazard identification would warrant. The agency has issued approximately 200 standards in its 50-year history. It has identified far more hazards than it has regulated, and for the hazards it has not regulated, workers are left to the same common law protections that existed before 1970, which is to say, very little. The enforcement problem is equally persistent. OSHA has approximately 150 federal inspectors to cover approximately 8 million workplaces. At that ratio, an average workplace can expect a federal OSHA inspection once every 165 years. The practical enforcement of OSHA standards depends heavily on complaint-driven inspections, triggered by worker reports of hazardous conditions, and on programmed inspections of high-hazard industries. But workers who report hazardous conditions face retaliation risks that are inadequately addressed by the law's whistleblower protections, and workers in the most vulnerable industries, agriculture, construction, meatpacking, are the least likely to report conditions to federal authorities. The COVID-19 pandemic exposed these enforcement limitations dramatically. When the pandemic began in 2020, OSHA had existing authority to issue an emergency temporary standard for biological hazards that presented a grave danger to workers. The agency declined to exercise that authority for most of the pandemic, issuing only a limited emergency standard for healthcare workers in 2021. Meatpacking plants, which became major COVID-19 hotspots in the spring of 2020, continued to operate with inadequate ventilation, inadequate spacing between workers, and inadequate access to protective equipment, because there was no applicable OSHA standard requiring otherwise and because the political environment was hostile to regulatory action. More than 50,000 meatpacking workers were infected with COVID-19 in the early months of the pandemic. More than 200 died. The industry lobbied successfully for liability protection from lawsuits related to COVID-19 worker infections. OSHA issued no fines for COVID-19 related worker deaths in meatpacking plants during this period. This is the legacy of the history we have been tracing, not a completed story of progress from the Triangle Fire to a world where workers are adequately protected, a story of partial progress, of real achievement, of persistent gaps, and of the continuing political struggle between the interests of employers who want to externalize the costs of worker risk and workers who bear those costs in their bodies and their lives. The 5,000 workers who die in American workplaces every year are not dying because workplace safety is impossible to achieve. They are dying in a country that has not fully committed to achieving it, that underfunds the enforcement agency responsible for it, that maintains penalty structures insufficient to deter the largest violators, and that exempts some of its most vulnerable workers from the protections it provides to others. The progress from 23,000 deaths per year in 1913 to 5,000 deaths per year today is real, and represents an enormous amount of human suffering prevented. The 5,000 who still die are equally real and represent an enormous amount of human suffering that better policy could prevent. Both of those things are true simultaneously. The history demands that we hold both of them in view. Subscribe if this kind of history is what you are here for. There is a great deal more of it ahead. There is a dimension of this history that connects the past most directly to the people most at risk today, and it is the dimension of who bears the cost of workplace risk in 2025. The workers who die in American workplaces at the highest rates are not randomly distributed across the workforce. They are concentrated in specific industries, in specific occupational categories, and in specific demographic groups in ways that reflect the same underlying dynamics that produce the inequality in workplace risk in the pre-OSHA era. Construction workers die at rates approximately 6 times higher than the average for all private industry workers. The construction industry has the highest absolute number of worker fatalities of any industry, accounting for roughly 1 in 5 workplace deaths despite employing roughly 1 in 15 workers. The specific hazards, falls from elevation, being struck by falling objects, being caught in or between equipment, electrocution, are well understood. The interventions required to address them, fall protection systems, overhead protection, lockout-tagout procedures, are well established. The gap between the available interventions and their consistent implementation is a product of the fragmented structure of the construction industry, where multiple subcontractors work on a single site, where liability is distributed across many parties, and where competitive pressure pushes each subcontractor to minimize costs, including safety costs. Latino workers die in construction at rates significantly higher than white workers. The concentration of Latino workers in the most dangerous aspects of construction, roofing, concrete work, demolition, reflects a labor market in which immigrant workers, particularly undocumented immigrants, are channeled into the highest risk work by a combination of limited alternative employment options, language barriers that make it harder to assert rights and understand hazards, and a fear of immigration enforcement that makes reporting safety violations practically impossible. The exploitation of this vulnerability is not accidental. Contractors who employ undocumented workers know that these workers are less likely to report violations, less likely to refuse dangerous work, and more likely to accept conditions that documented workers would contest. The immigration status of workers becomes a safety management tool, used to maintain conditions that could not be maintained if the workforce had the practical ability to assert its legal rights. The meatpacking industry presents a similar pattern. Line speeds in large meatpacking facilities have increased dramatically since OSHA's creation, as the industry has used its political influence to resist OSHA regulation of line speeds and to prevent the agency from setting ergonomic standards that would have required reduction in the pace of work. The workforce in large meatpacking facilities is predominantly immigrant and Latino, and the industry has built its business model around the willingness of this workforce to perform extraordinarily demanding work at very high line speeds for wages that are low relative to the injury rates the work produces. The repetitive stress injuries produced by meatpacking work, carpal tunnel syndrome, tendinitis, nerve damage in the hands and wrists, are among the most common occupational injuries in any industry. They are also among the most underreported because workers who report injuries face the risk of losing their jobs, because the piece rate compensation structures used by some processors create financial pressure to keep working through pain, and because the healthcare access for workers in this industry is limited enough that many injuries go untreated as well as unreported. Agriculture presents yet another variation on the same theme. Farm workers have fatality rates roughly 7 times higher than the average for all private industry workers. They work with machinery that has limited guarding requirements compared to industrial equipment covered by OSHA standards. They work in heat that has killed hundreds of workers in recent years, in states that have been slow to implement heat illness prevention standards. They are exposed to pesticides without adequate training or protective equipment in many cases. And they work in an industry that is partially exempt from the OSHA standards that apply to other industries, a legacy of the agricultural exemption in the original law that has never been fully corrected. The political economy of these exemptions and enforcement gaps is the same as the political economy that produced the pre-OSHA system. Industries with the most to gain from weak regulation are the most politically active in resisting regulation. Workers with the least political power are the ones most exposed to the hazards that weak regulation permits. The distribution of workplace risk follows the distribution of political power with a consistency that is not coincidental. The argument that more stringent workplace safety regulation would cost jobs and reduce competitiveness has been made in every decade since the first factory safety laws were proposed in the 19th century. It was made against child labor laws. It was made against the 8-hour day. It was made against workers' compensation. It was made against OSHA. It is being made today against proposals to strengthen OSHA enforcement, increase penalties, and close the agricultural and gig economy exemptions. The empirical record does not support the argument. The countries with the strongest workplace safety regulatory frameworks are among the most economically productive in the world. The states within the United States that have stronger occupational safety regulation do not systematically have lower employment or slower economic growth than states with weaker regulation. The cost of workplace injury and death, borne by workers, their families, their communities, and ultimately by the healthcare system and social support programs that treat and compensate them, is a real economic cost that does not disappear by being transferred from employers to workers. It simply becomes invisible in the calculation of business costs. The Triangle Shirtwaist factory was profitable until the fire. The fire was not a business cost before it happened, because the cost of preventing it, fire escapes, unlocked doors, sprinkler systems, was being borne by the workers rather than the owners. After the fire, the owners paid $75 per worker killed, were acquitted of manslaughter charges, and eventually collected insurance money that exceeded the value of the property lost. The workers absorbed the rest. This calculation, in which the cost of safety is a cost borne by workers in the form of injury and death rather than by employers in the form of investment, is the fundamental economic dynamic that workplace safety regulation is designed to correct. OSHA has corrected it partially in some industries, for some hazards, for some workers. It has not corrected it fully for all industries, for all hazards, for all workers. The gap between what has been corrected and what remains to be corrected is the gap between the world of 1911 and the world of 2025, measured not in years, but in the difference between 23,000 deaths per year and 5,000 deaths per year. Both numbers are real. Both represent choices that were made by employers, by regulators, by legislators, and by the political system that determines what protections workers receive. The 5,000 workers who will die in American workplaces this year will do so in a country that has a federal workplace safety law, that has an agency responsible for enforcing it, and that has made significant progress from the world of the Triangle Fire and the Monongah Mine and the phosphorus necrosis of the match factory workers. They will also die in a country that underfunds that agency, that maintains penalties too low to deter wealthy employers, that exempts its most vulnerable workers from full protection, and that has repeatedly allowed industries with political power to block the regulatory standards that would have kept more of those workers alive. The history of workplace safety in America is not a history that has reached its conclusion. It is a history that is still being written in the regulatory proceedings and legislative debates and enforcement actions and legal challenges that determine, year by year, which hazards will be regulated and which will remain the private burden of the workers who are exposed to them. The 14-year-old who died at the Triangle factory in 1911 is the beginning of that history. The construction worker who falls from a scaffold in 2025 is part of the same story. The distance between them, measured in law and in lives, is the measure of how far the country has come and how far it still has to go. That is the history, and it is not finished. Subscribe if this is the kind of history you are here for. There is more ahead. One final thread in this history deserves attention because it connects everything that has come before to a question that is actively being debated right now in 2025 in regulatory proceedings and in Congress. That question is whether the trend of declining workplace fatalities, which has been the story of the past 50 years, is going to continue, or whether the political and regulatory environment of the current era is going to reverse it. The evidence from the past decade is mixed. Workplace fatality rates declined steadily from OSHA's creation through the early 2000s, then leveled off, and have shown only modest improvement since. The construction fatality rate has not declined significantly in the past decade despite it being the most lethal major industry and despite the availability of effective preventive measures for its most common causes of death. The agricultural fatality rate has similarly stagnated. The heat illness problem is becoming more acute as climate change increases the frequency and severity of extreme heat events. Workers who perform outdoor physical labor in states with hot climates, farm workers, construction workers, utility workers, landscapers, are facing temperatures that were not previously common in their work environments and that exceed the physiological limits of safe work without adequate rest and hydration. OSHA issued a proposed heat illness prevention standard in 2024, after years of advocacy from worker safety organizations following the deaths of multiple workers in heat events. The standard faces opposition from agricultural and construction industry groups who argue it is too costly and too prescriptive. The opposition follows a familiar script. The same arguments that were made against requiring fire escapes in 1911, against requiring automatic couplers on railroads in the 1890s, against requiring ventilation in coal mines in the early 20th century, are being made today against requiring water, rest, and shade for workers in extreme heat. The cost is too high, the regulation is too inflexible, the market will address the problem, workers can protect themselves, the market has not addressed the problem, workers cannot protect themselves when their employers control their work schedules and their access to shade and water, and the cost of not addressing it, measured in worker deaths from heat illness, is being borne by the workers, not by the employers or by the political system that has failed to act. This is the continuity between 1911 and 2025 that the history demands we recognize. The specific hazards change, the industries change, the workers at greatest risk change. The fundamental dynamic in which the cost of workplace risk is transferred from those who profit from the work to those who perform it does not change. Addressing that dynamic permanently and comprehensively is the unfinished project of American workplace safety law. The Occupational Safety and Health Act of 1970 was a beginning. It established the principle that the federal government has the authority and the obligation to set and enforce minimum safety standards in American workplaces. That principle was a genuine advance over the 181 years that preceded it. What the principle requires in practice: adequate funding, meaningful penalties, comprehensive coverage, effective enforcement, and the political will to maintain all of these against persistent opposition from the industries with the most to gain from safety shortcuts, is still being negotiated, 50 years after the law was passed, in the same political arena where it has always been negotiated. The workers who died at Triangle in 1911 did not get to participate in that negotiation. Their deaths produced a political response that led, eventually, to the laws that protect workers today. The workers who are dying today, in construction sites and meatpacking plants and farm fields, are producing their own political pressure through the advocacy organizations that document their deaths and the legislators who carry their cases into the regulatory process. Whether that pressure produces the next round of improvements, the heat standard, the ergonomic standard, the stronger penalties, the closed exemptions, is a political question being answered right now. The history says that progress is possible. It also says that progress requires sustained political will against sustained opposition, and that in its absence, workers continue to die in ways that are preventable. That is where the story of American workplace safety stands in 2025. Not at the end, not even close to it. Subscribe if you want to keep following this kind of history. There is a great deal more of it ahead. To close this story completely, it is worth returning to the Triangle Shirtwaist factory one more time, not to the fire itself, but to what happened in the years immediately after it, because what happened in those years tells you something important about how safety progress actually occurs and what is required to sustain it. In the weeks after the fire, 80,000 people marched through the streets of Lower Manhattan in a funeral procession for the victims. The political pressure produced an immediate response. New York State established the Factory Investigating Commission, led by Robert Wagner and Al Smith, two politicians who would go on to significant national careers, and charged it with systematically investigating conditions in New York factories. The commission spent 4 years investigating. It documented conditions across hundreds of factories, found hazards similar to those that had killed the Triangle workers in facility after facility, and produced 56 pieces of legislation that fundamentally transformed New York's factory safety law. Fire escapes, unlocked doors, sprinkler systems, fire drills, maximum occupancy limits, improved ventilation, reduced working hours for women and children. All of these became legal requirements in New York State within 4 years of the Triangle Fire. New York became, as a result of those 4 years of legislative work, one of the safest industrial states in the country. Workers in New York factories were safer in 1915 than workers in comparable facilities in states where no equivalent political pressure had produced equivalent reform, but workers in those other states were not protected. The improvement in New York did not translate automatically into improvement in the textile mills of the South or the steel mills of Pennsylvania or the mines of West Virginia. Federal legislation that would have nationalized the New York reforms was blocked in Congress for decades. This is the structural limitation of state-by-state reform that characterized American workplace safety regulation from the Progressive era through 1970. Individual states could be moved by specific disasters, by organized political pressure, by reformist politicians like Wagner and Smith who were willing to expend political capital on worker protection. But the states where conditions were worst, where the most dangerous industries were most politically powerful, were precisely the states where reform was hardest to achieve. Federal legislation was the only solution to this problem. It was the solution that finally came in 1970, 59 years after the Triangle Fire, because the political conditions that made it possible had not existed earlier, and because the industries that opposed it had successfully blocked it every time the political window opened slightly before 1970. The lesson of that 59-year gap is not that progress was impossible. The New York Commission demonstrated that progress was possible when the political will existed. The lesson is that progress confined to individual states leaves workers in the most dangerous conditions in the most anti-regulatory states with no protection, and that the workers who most need protection are typically in those states. In 2025, the same dynamic is visible in the variation between states in their approach to workplace safety. California has a state occupational safety plan that is generally more stringent than federal OSHA standards, more inspectors per worker, higher penalties for violations, and additional standards in areas like heat illness prevention, where the federal agency has been slow to act. Texas relies almost entirely on federal OSHA enforcement, has no state occupational safety plan, and has workplace fatality rates significantly higher than California despite similar industrial compositions. This variation is not random. It reflects the political economies of different states, including the relative power of employers and workers, the receptiveness of state governments to regulatory action, and the presence or absence of the kind of political pressure that produced the New York Factory Investigating Commission after the Triangle Fire. The federal floor established by OSHA means that workers in Texas have some protection they would not have without the law. The federal floor also means that workers in California have better protection than the federal minimum because California has chosen to go further. And it means that workers in the most dangerous industries, in the states with the weakest regulatory cultures, continue to bear risks that better regulation would prevent. The Triangle Fire killed 146 workers on a single afternoon. American workplaces kill 5,000 workers every year, quietly, one at a time, in construction accidents and agricultural heat deaths and meatpacking repetitive injuries and chemical exposures. The aggregate is as large as the Triangle Fire every 10 days. The political pressure is correspondingly smaller because the deaths are dispersed rather than concentrated, because they do not produce the kind of visible horror that 146 bodies falling from a building produces, because the workers who die are often the workers with the least political visibility. The job of making their deaths visible, of connecting them to the systems that produce them, of translating individual tragedies into political pressure for systemic change, is the job that reformers have been doing since Alice Hamilton visited the first lead paint factory in 1910. It is a job that is still being done by worker advocacy organizations and union safety representatives and investigative journalists and OSHA inspectors and plaintiff attorneys, and the families of workers who died in preventable accidents. It is also, in a small way, the job of a video like this one. Understanding where the current system came from, what it has achieved, and where it still falls short is the beginning of being able to demand something better, from the Triangle Fire in 1911 to the OSHA Act in 1970, from 23,000 deaths per year to 5,000, from no federal standard to 200 OSHA standards covering 130 million workers, and still 5,000 deaths per year. Still gaps, still exemptions, still penalties too low to deter, still workers bearing risk that the law has not yet reached. That is the full history of American workplace safety. And the next chapter is still being written. Subscribe if you want to keep following it.